My name is Okeke Trauma and I'm a trainee solicitor at Mayfield Solicitors in Watford, ID number 23038-265. And today we'll be looking at this. Today I will be taking you through sections 13 to 15 of the Sale of Goods Act 1979, and we'll be focusing on the implied terms that protect buyers in this act. Now imagine if you just bought a brand new car and within a day or two the engine fails. Now can you return the car or can you demand for compensation? This is where the Sale of Goods Act 1979 steps in. Even if a contract is silent on certain terms, the law ensures that essential protections are automatically applied or included in these contracts, known as implied terms. Contracts for the sale of goods can either be express or implied. Express means that they are clearly agreed, or the terms are already agreed, or they are stated in the contract. And these we can see in contracts, while implied are those automatically applied or included by the law. Now, why are implied terms so important? They're important because sellers do not always include the definitions or the descriptions of what they sell. We do not always know every detail of what they are selling, and without them, a buyer could receive low standard goods without any consequences going to the seller. And it prevents sellers from escaping liability by omitting critical information. Let's say you purchased a brand new iPhone 15 Pro, where you open the box or you open the package and you see an iPhone 11. That is a clear breach of Section 13 of the Sale of Goods Act 1979. The Sale of Goods Act Section 13 subsection 1 states that goods sold by description must match the description given in the contract, and this protects buyers from misrepresentation. This section also ensures contractual certainty. Now we're going to take a look at a case, the case of Arcus Ltd versus Ronerson and Sons 1933. Here, even a slight variation in dimension was enough to justify rejecting the goods. And then we also look at the case of Bale versus Taylor 1967, where a second-hand car advertised as a 1961 Triumph Herald was actually two-wielded cars together. They were welded together, two different cars, and the seller breached Section 13 despite the buyer inspecting this car. This is a strict rule, and even minor deviations can justify contract termination. But instead, if a buyer relies on their own expertise, Section 13 then does not apply. But if a product does not exactly match its description, the buyer can reject it and claim for damages. Now, under Section 14, subsection 2 of the Sale of Goods Act, this is where goods are sold in the course of business. They must be of satisfactory quality. But what do we mean by satisfactory quality? This is outlined in the next subsection, and it sets out 5 key factors. That is fitness for common purpose, appearance and finish, freedom from minor defects, safety, and durability. And we'll take a look at the cases of Rogers versus Parrish. This is where a new Range Rover had minor defects, including a noisy engine and scratches. And the court ruled that even small defects on new goods or new items can amount to a breach of Section 14, subsection 2. Also, we have the case of Bartlett versus Sydney that shows that we have to be careful on how this rule is handled, because not all defects result in a breach. Here, a second-hand car developed a defect, and the court held that a lower standard applies to used goods, meaning that buyers cannot expect perfection of used goods. Now, let us explore the limitations of Section 14, subsection 2. There are some exceptions where the implied term of satisfactory quality does not apply. Under section 14 subsection 2c, the term is excluded if a. The defect was already disclosed before the sale, or if the buyer examined the goods and should have noticed the defect before the purchase. Lastly, the sale was by sample and the defect should have been apparent. For instance, if you want to buy something off eBay and is a second-hand item and it has the defect stated there, then this implied term is excluded. And today we'll be looking at some key cases. We're looking at Harlenden versus Christopher Hall, 1991. In this case, a painting was said to be made by a famous artist, and the seller had no knowledge of art, but the buyer had specialist knowledge in fine art, and he did not rely on the seller's description. The court held that by section 13 did not apply, as the buyer had already relied on their own expertise and not the description outlined by the seller. Now that we have covered satisfactory quality, we will move to fitness for purpose under section 14, subsection 3 of the Sale of Goods Act 1979. This provision applies when a buyer informs the seller of a specific purpose for which they require the goods. In such case, there is an implied condition that the goods must be reasonably fit for the purpose stated. Now, not all buyers are product experts, so often they rely on the expert of the seller or the seller's advice and expertise to ensure that they are buying the right product or good. So if the seller recommends something that turns out to be unsuitable, Section 14 subsection 3 allows the buyer to seek remedy. But there are two key requirements for this to happen. First of all, the buyer must communicate their intended use. So if they remain silent, the seller is not responsible for the goods being unfit. And we're going to take a look at the case of Peter Conway, 1939, where a buyer purchased a wool coat but later developed a skin reaction due to her sensitive skin. Here the court ruled that there was no breach, as the buyer did not inform the seller about her sensitivity. So if the buyer has special requirements, they must state them explicitly. And secondly, the buyer must rely on the seller's expertise. So if the buyer chooses independently or has greater knowledge than the seller, Section 14 subsection 3 will not apply, just like the case of the painting that we looked at previously. The section we'll be looking at today is Section 15 of the Sale of Goods Act, which applies when goods are sold by samples. So this ensures that the buyers who are shown a sample before the purchase can expect the bulk of the goods or the goods they receive to match the sample that they saw. So Section 15 requires that A, the bulk must match the sample in both quality and condition, and B, the goods must be free from hidden defects and that were not apparent during the viewing the sample. The key case we're going to look at is Godley versus Perry, where a shopkeeper purchased a batch of toy catapults after inspecting a perfect sample. But this sample turned out to be defective and injured a child. Here, the court held that the seller could simply reject the goods under Section 15 as the bulk did not conform to the sample. It is very important to note that a perfect sample does not excuse defects in the full batch. And now, we can look at what remedies are available when implied terms are breached. Seller breaches Section 13, 14, or 15. The buyer has legal options for remedy, but this depends on the type of breach and the severity of the breach. So, for instance, if there was a breach of condition that involves almost all the sections that we looked at today, the buyer can reject the goods, terminate the contract, and they also may still claim for damages of any losses. But when it's a breach of warranty, the buyer cannot reject the goods but may claim damages instead. That's all that we can under Section 13 to 15 of the Sale of Goods Act, and focusing on implied terms. That is it for today, and we can see our bibliography here, including all the relevant case law and precedents. Thank you.